16. There they found a broken beer bottle and glass from what appeared to be a broken headlight. On the way to headquarters to file a report, 2 officers concluded that there was an indication that drunk driving had been involved. On the way, they passed the home of the defendant, Phil Carter, noticing that the lawn seemed to indicate a recent episode of reckless or uncontrolled driving. In addition, Officer Simpson will tell you that the candidate Cherokee in the garage was dancing with a broken front headlight. This warranted further investigation. Officer Simpson will tell you that when she went to the door, Jerry Carter, Phil's sister, invited her into the home. There, she found a matching set of pom-poms and a Westville college cap. 2 items that were identical to the ones described by the accident victim. When they interviewed the accident victim earlier, she told them that she had been jogging when a white-colored car, being driven wildly and at a high rate of speed, came out of nowhere and struck her. She also told them that before she was hit, she noticed that the driver had a red and white Westville college cap and matching set of pom-poms, identical to the ones found in the house. When Officer Simpson talked to Phil, he told her that she learned that he had been drinking at the graduation party, and that all of this accumulation of evidence led her to believe that Phil had been involved in the hit and run. So she began to read his Miranda rights as required by the 5th Amendment to the United States Constitution. She would tell you, however, that she would stop midway, and Phil Carter waived his rights. It was after this interruption, upon hearing that a woman had been hit, that Phil Carter confessed, saying, and I quote, "I must have hit her. I'm sorry." Meanwhile, Officer Peterson noted that the car in the garage was parked crookedly, damaged, and that the lawn outside was damaged, and that this mounting evidence led her to believe she had probable cause to search the car. There, she found 2 beer bottles identical to the one found at the accident scene, and a half-smoked marijuana cigarette. These items of evidence, along with his confession, that the defense seeks to suppress. Ladies and gentlemen, the defense will claim that these actions were illegal because they were without warrant. The Supreme Court has, however, made 3 exceptions to the warrant requirement. First, the search can be made with consent. You can see that Officer Simpson had consent. Jerry Carter welcomed her into the home. Second, the search can be made in an area in plain view. Both the automobile in the open garage and the cap and compounds on the kitchen table were obviously in plain view. Finally, the search can be made if it is during an emergency, including instances when it is likely that the evidence would be destroyed. You will see that surely these officers could reasonably conclude that the damaging evidence they found would not be left untouched. And ladies and gentlemen, perhaps most importantly, Phil Carter waived his 5th Amendment rights. That's to an accident which took a life. Members of the jury, while the evidence obtained that day may unfortunately be damaging to Phil Carter's case, it was not obtained illegally. And at the trial today, we will ask you to deny the defendant's motion to suppress, to allow this evidence to be used when Phil Carter is brought to trial. Thank you.
All right, thank you very much. At this point, is the defense ready to proceed with an opening statement?
Yes, Your Honor.
All right, you may do so.
Good afternoon, Your Honor. Members of the jury. I'm Matthew Carafin of the defense, and my co-counselors are Colin Rook and Jay Wang. In 1787, 55 of the greatest minds in history came together at one time to create a document that would shape the way of life for all citizens in this great nation. This document, the Constitution, gave all people, regardless of age, race, or religion, certain rights that would guarantee a citizen life, liberty, and the pursuit of happiness. Here today, in 1995, one of those 10 original and inalienable rights have been violated. That right was the 4th Amendment, which states the right of the people to be secure in the persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. We'll prove that on June 10, 1994, 2 preliminary investigating officers, Officers Peterson and Simpson, entered the property of my client, Phil Carter, not in any hot pursuit, and not only searched inside the vehicle of my client, but entered the house of my client, finding it perfectly normal to enter the house with only the consent of Jerry Carter, Bill's 11-year-old sibling, without a warrant. The circumstances surrounding this violation was that on June 10, 1994, a young girl was hit by a car and tragically died 2 days later from injuries. My client, Bill Carter, a track star and a senior economics major at Westville College, was wrongly accused of this heinous crime. This mistaken judgment was a direct result of two officers, Simpson and Peterson, who in their investigation did not follow legal procedures. We'll prove that the evidence received should be suppressed because the officers did not follow procedures for one, not doing their job since their only responsibility was involved with preliminary investigation. The evidence will show that nowhere in either police officer's affidavits have these two officers been said to be responsible for full investigations. 2, not filing an accident report until after the arrest of my client. 3, not gaining a search warrant before searching the property of my client. 4, not listening to the reasons or check the alibi of my client. The evidence will show that the damage to the car was a direct result of hitting a pole at another intersection, Park and Maya. And the bottles of beer found in my client's car were from Bobby Joe Jones, Officer Peterson's cousin, and not my client. 5, not reading my client's full Miranda rights. 6, not checking the alcohol level or visual acuity of their eyewitness. The evidence will show that their eyewitness was in no condition to be sure of what transpired on the accident at the accident scene. Based on her own affidavit, Jean Jones had wine a few hours before the accident and had recent eye surgery concerning a detached retina and was wearing amber vision glasses at the time of the accident. The only facts that have incriminating my client was witnessed by a person who at the time was drunk and visually impaired. From these facts and testimonies that are to follow, we the defense shall prove that the evidence gained by officers Peterson and Simpson were gained in an unconstitutional manner and should be suppressed. We hope you find this case in favor of the defense. Thank you.
Thank you, sir. All right, at this point, is the prosecution prepared to call in first witness?
Yes, Your Honor. The prosecution calls Officer Simpson to the stand. Your Honor, while the witness is walking to the stand, I'd like to provide you with a copy of the stipulation as to the authenticity of the documentary evidence that we used today.
All right, any objection to the stipulation that's in accordance with your understanding?
There you are.
Counsel, do you want to identify yourself for the record, please?
My name is Juliana.
Okay. Swear the witness?
State your full name,
Officer Christine Simpson.
spell your last name.
S-I-M-E-S-O-N.
Swear to tell the truth, the whole truth, nothing but the truth, so help you God.
I do.
Please be seated. What's up?
Officer Simpson, are you a police officer with the Westville Borough Police Department?
Yes, I am.
What is your rank?
I'm a patrol officer.
And how long have you been with the force?
For about 10 years.
What duties does your job entail?
I perform preliminary investigations, dispatch response, and sector patrol.
Are you assigned to any particular geographical area?
Yes, Sector A.
Where is Sector A?
Sector A is bordered by the streets Market and Elm.
What are your usual hours?
I usually work from 11 a.m. to 7 p.m.
About how many arrests and searches have you performed in your 10 years with the force?
I participated in well over 300 arrests and almost as many searches.
Let me direct your attention to June 10th, 1994, the day of the arrest of the defendant, Bill Carter. Were you involved in any way with that arrest?
Yes, I was.
Where did your involvement begin?
I overheard a call from dispatch reporting an auto accident.
What type of accident was this?
It was a hit and run.
Could you please explain to the jury what you mean by hit and run?
A hit and run is a term we use when a vehicle involved in an accident leaves the scene of the accident.
About what time was this accident?
It was around 6:45 p.m.
And where did it occur?
It was reported to me on the intersection of Market and Elm.
Is that in your sector?
Yes, it is.
Did you do anything when you overheard the call?
Well, even though I heard Officer Peterson had responded, I knew from experience that this type of job required backup. So I went to the accident scene.
When you got to the scene, could you tell us what you saw?
Well, I saw an ambulance leaving the scene and that that Officer Peterson was talking to the eyewitness, Jean Jones.
Did you learn anything about the accident?
Yes, I learned that there was one injured victim who was taken to Westville Hospital, and that the vehicle involved had fled the scene.
Did you find any evidence?
Yes, we found one broken beer bottle near the street, near the curb on the street.
Where did the investigation go from there?
Well, we went to Westville Hospital to see if we could interview the victim, Mary May.
Did you learn anything about the accident from Miss May?
Yes, we learned that Mary May was jogging east on Elm, as is part of her usual routine. After looking both ways, she proceeded to cross the intersection. At the middle of the intersection, a large light-colored car came toward her.
Did the victim remember anything else?
She remembered seeing a red and white Westville College cap and matching set of pom-poms on the passenger side of the dashboard.
What was the victim's apparent physical condition?
She looked badly injured.
Okay, after you concluded the interview with Miss May, what did you do next?
We decided to go back to the station to see if we could match any of the vehicle descriptions without the stolen or abandoned vehicle reports. On the way back, though, we passed the defendant's home.
Did you see anything important at the defendant's home?
I happened to notice a crushed azalea bush on the corner of the Carter's driveway.
Could you tell how this bush was crushed?
It appeared to have been run over by a vehicle.
Where were you when you saw this bush?
I was on the street as we were driving by.
Did you see anything else at the Carter home?
Yes, I saw freshly made tire marks on the Carter lawn.
And where were you when you saw this?
I was on the street as we were driving by.
Did you see anything else at the Carter home?
Well, since the garage door was open, I happened to notice a tan Jeep Cherokee in the garage.
And where were you when you saw this?
I could see it clearly from the street.
Did you notice anything about the exterior of the car?
Yes, I noticed that it had a dent in its left front quarter panel and a broken left headlight.
And where were you when you saw this?
I was on the street.
Did you conclude anything about the damage to the Jeep?
Yes, it was apparent to me that the Jeep had been in an accident.
Okay. After you had seen all of these things, the azalea bush, the tire marks on the lawn, and the damage to the Jeep, did you decide to do anything?
I decided to go to the Carters to speak to them about the damage to the car.
What happened next?
I rang the doorbell and Jerry, Phil's younger sister, answered.
Do you know how old Jerry is?
No.
Is Jerry a full-grown adult?
No.
Is Jerry a baby?
No.
Is Jerry of adolescent age?
Yes.
Does Jerry seem to speak and understand the English language?
Yes.
Is Jerry acting confused, deranged, or intoxicated in any way?
No.
What happened after Jerry came to the door?
She invited me in.
Was there anyone else there to tell Jerry otherwise?
No, I didn't see anybody else around.
What happened after Jerry invited you in?
I happened to notice a Westville College cap and matching set of pom-poms on the kitchen chair.
And where were you when you saw these?
I was entering the kitchen from the front entrance area of the house.
What happened next?
I walked into the family room and saw Phil watching TV.
Did you talk to Phil?
Yes.
Please tell us about your conversation.
Well, Phil said that he had been driving that day and that the Jeep was now in the garage.
And where had Phil driven to that day?
He said he had gone to a graduation party where there had been drinking and that he had gotten into a car accident while he was there.
Did Phil say anything else?
He said that while he was driving, he had felt a little tipsy.
And what happened next?
Well, I began to suspect that Phil might have been involved in the hit and run.
Did you do anything?
Yes, I did what I was supposed to. I began to read him his Miranda rights.
Could you please explain to the jury what you mean by Miranda rights?
I am required to advise the criminal suspect of his right to remain silent and of his right to have an attorney.
Did you complete the reading of the Miranda rights?
No, Phil interrupted me and said that he did not need to have his rights read. He would answer my questions anyway.
Did Phil say this of his own free will?
Yes.
Was there anyone else in the room who could have influenced Phil to say this?
No.
Were you coercing or intimidating Phil in any way?
No.
What happened next? Did you ask Phil any questions?
Yes, I did.
Could you please tell us what questions you asked Phil and what he said in response?
Well, I asked Phil to tell me what had happened from the time he had left the graduation party. He said he had left around 6:15 p.m. and had admitted to feeling tipsy while driving home and had hit a telephone pole. He said he had driven home directly from there.
Was there any discussion of the accident involving Mary May?
Well, I told him that I was relieved that he hadn't been involved on the accident on Market and Elm because the victim was a pretty 19-year-old young woman.
What was Phil's reaction to this?
After a few moments, he confessed.
And what exactly did Phil say in that confession?
He said, I must have hit her, I'm sorry.
Did you ask Phil any more questions?
Well, I tried, but he refused to answer them. So I told him he would have to accompany me to the police station and have a blood alcohol test.
What happened next?
I placed Phil under arrest and escorted him out of the house.
Did you take anything from the Carter home?
Yes, from the kitchen, I took the red and white Westboro college cap and matching set of pom-poms that matched the description the victim had seen inside the hit-and-run vehicle.
Thank you, Your Honor. I have no further questions.
Very well. Cross-examination. Counsel, you want to identify yourself, please, for the court? Thank you. You may proceed.
Officer Simpson, do you consider yourself a law-abiding officer?
Yes.
Did you not state in your own affidavit you have made many arrests without a warrant?
Some with, some without.
Your Honor, would you please instruct the witness to yes or no?
I think she accurately answered the question. You may proceed.
Did you have a warrant when you entered the Carter home?
No.
Do you think you had probable cause to enter the house and arrest my client?
Yes, I do.
On what grounds?
Well, based on what I had seen, the daily version, the erratic driving that was evident when I went up to the house, and the broken beer bottle come scene, we surmised that, yeah, she did have probable cause.
Was your original intention to ask about this run over as illegal?
Yes. Well,
Have you completed your answer? I'm sorry?
no.
Did you want to complete your answer?
I had planned to ask the Carters about the damage to their car.
From the front door, where you entered, could you see the pom-poms and cap?
No.
In fact, it was not until you entered the second room, the kitchen, that you noticed this evidence, correct?
From the doorway, yes.
Stop me if I'm wrong. Westboro College, I would assume, was like any other county college. Wouldn't you say that the odds of only one student in the history of that school buying red and white pom-pom caps are unbelievable?
Yes.
When you got to the Carter home, Jerry let you in, correct?
That's right.
And Jerry is 11, a minor, correct?
I don't know how to
Objection,
tell.
Your Honor. This is beyond the scope of this witness's affidavit.
You don't know the age of Jerry?
No.
Your Honor, this witness did not testify in her statement as to the exact age of Jerry Carter.
She has no knowledge of any other of the prosecution's witness's statement.
No, Your Honor. Only her own statement.
No help over there. At this point, I'll sustain the objection. May proceed.
When you encountered Phil, could you tell if he was under the influence of alcohol?
I saw you have been drinking.
Want to keep your voice up, please, so the members of the jury can hear you?
Could he have knowingly and intelligently waived his Miranda rights and his condition?
Yes, I believe so.
Well, his blood alcohol level was 0.14, which is 4/100ths over the legal limit.
Objection, Your Honor. This is irrelevant.
I am merely
Want to respond to the objection?
I'm merely trying to state that he could not have knowingly and intelligently waived his Miranda rights. Therefore,
Thank you. Rephrase the question.
after the arrest, you did not check Phil Carter's alibi, correct?
No.
After leaving the scene of the crime, did you go straight to the hospital?
Yes, we did.
In your affidavit, though, you stated that you stopped off at headquarters. Page 1, second paragraph, bottom line.
I didn't have one.
Officer Chris Simpson.
Yes.
Right here. You clearly stated, I agreed.
It's a statement. I didn't have an affidavit.
In your statement, I agreed that we dropped off my cruiser at the hospital, or at headquarters. Officer Peterson also stated he went to headquarters first.
Okay. We went to headquarters and dropped off my cruiser.
Did you pick up or did you file an accident report while there?
No, we did not.
So, explain this to me in a layman language. You entered my client's home with no warrant and no evidence against him. You gained access to the car home through an 11-year-old.
Objection, Your Honor, this is argumentative.
Did you complete your question? Wait a minute, did you complete your question?
No.
You may complete your question, then if you think it's appropriate, you may object. Proceed.
You gained access to the Carter home through an 11-year-old and decided you were going to accept a confession for a drunken and upset man. After that, you never did go to the intersection of Park and Maya to see if his alibi checked out. Does that sound correct to you?
Now, Your Honor, this is argumentative.
No, I think it's a proper cross-examination. Overrule the objection, you may answer the question.
Does that sound correct to you?
Well, I didn't know that Jerry was 11 years old. And I didn't think that Phil was upset. And I don't think he was that drunk.
You stated
I'm sorry, what was your answer? What was that last answer?
I don't think he was drunk.
Did you say drunk or that drunk?
That drunk.
Okay,
You
proceed.
did state in your statement that it was quite apparent that Phil had been drinking heavily.
He had been drinking. You could tell.
Heavily means he's been drinking quite a bit, which could be 4 to 5 years.
Counsel, keep your voice up so that I can hear you, please.
Sorry. So, does that sound correct to you?
What?
My final question.
You want the question repeated?
Yes, please.
You entered my client's home with no warrant and no evidence. You gained access to the Carter home through minors and decided you were going to accept a confession to a drunk and upset man. After that, you never did go to see if Phil Carter's alibi checked out.
Objection, Your Honor, this is may ask the answer.
And how is your question different from the way it was asked before?
It's not.
Okay, then I'll say the objection. Next question.
No further questions.
Very well. You may sit down. Prosecution have additional witnesses?
Yes, Your Honor. Prosecution calls Officer Pat Peterson.
Just correct. His full name,
Pat Peterson,
spell your last name.
Peterson.
You swear to tell the truth, the whole truth, nothing but the truth, so help you God.
Yes, I did.
Officer, are you employed by the Westville Borough Police Department?
Yes,
In what capacity?
I'm a patrol officer.
How long have you been there?
About 7 years.
As a patrol officer, what does your job include?
I perform preliminary investigations of all incidents from loud parties to serious crimes.
Officer, were you in the courtroom when Officer Simpson testified?
Yes, I was.
Did you listen carefully to her testimony?
Yes, I did.
In order to save time, is there anything you would like to add to what Officer Simpson described as happening at the accident scene?
Yes, I'd like to add some more details to my interview with Gene Jones, and also add that glass from a broken headlight was also found at the scene.
Okay, could you tell us about your interview with Gene Jones?
Yes, he kept repeating how awful it was to see that poor young woman hurled through the air and land in the parking lot next door. He told us as he ran toward the victim, he saw the driver throw what appeared to be a beer bottle out of the window. He also said when he reached the victim, she was unconscious but still alive. He ran home, dialed 911, and returned to the victim until the ambulance arrived.
What did you do with all this information?
I wrote it down to file a report later.
Then what did you do?
Gene Jones led us to where he felt the bottle had landed.
Did you find it?
Yes.
Did you find anything else there?
Yes, glass which appeared to be from a broken headlight.
What did you do with all of this evidence?
I placed them in a plastic evidence bag, labeled, dated, and initialed the outside of the bag.
Okay, officer, is there anything you would like to add to what Officer Simpson said happened at the interview with Mary May?
No.
Okay, then let's pick up with when you left the hospital. Do you remember what time this was?
Almost 7:50.
Where were you headed?
Back to headquarters.
At this time, had you written your report on the interview with Mary May?
No. That's why Officer Simpson agreed to drive so that I could finish my report.
Did you talk to Officer Simpson?
Yes.
About what?
I told him the facts of the case and discussed possible theories.
Did you develop any?
Yes.
What?
I surmised from the broken beer bottle found at the scene and the drunk driving, the erratic driving which Mary May had described, that drunk driving was probably involved.
At this point, did you have any suspects?
No.
Did anything else happen on the way to headquarters?
Yes, we drove down June Lane and passed the defendant at Bill Carter's home.
Did you see anything as you approached the Carter home?
Yes, there were fresh tire marks in the grass and an azalea bush appeared to be run over by a vehicle.
What was your reaction to this?
I found it suspicious, so Officer Simpson turned the car around and pulled over.
Then what happened?
Officer Simpson asked me to drive Gene Jones home and return.
Did you?
Yes, I did.
What did you do when you came back?
I noticed the beige Jeep Cherokee in the garage.
Were you in the garage at this time?
No, I had just gotten out of my vehicle and was walking towards the garage.
And then what happened?
I noticed that the vehicle was parked very crookedly, that the front left headlight was broken, and the left front quarter panel was dented.
At this time, Officer Peterson, did you form any conclusions?
Yes.
What?
I thought that the vehicle might contain evidence.
What did you base this on?
Well, I thought about everything I had seen that day. The broken beer bottle found at the scene. This vehicle was similar to the description which Mary May had given us. The tire marks in the grass, the run over azalea bush, and the crooked car position.
So at this time, what did you decide to do?
I decided to enter the garage and inspect the vehicle.
Were you looking for anything specific?
No.
What did you do next?
I checked the exterior.
Did you see anything relevant to your investigation?
Nothing outside the dent or the broken headlight.
So then what did you do?
I looked inside the driver's side window.
Did you see anything?
Yes, 2 empty beer bottles were in the back seat.
Were these beer bottles similar to the one found at the accident scene?
Yes, identical.
So what did you do?
Because the front door was open, unlocked, I entered the vehicle and retrieved the 2 bottles.
Did you find anything else in the car?
Yes, there was a half-smoked marijuana cigarette in the ashtray.
And what did you do with all of this evidence?
I placed them in plastic evidence bag, labeled, dated, and initialed the outside of the bag.
Your Honor, may I approach the witness?
Yes.
Let the record reflect that I am presenting the witness with what has been pre-marked as prosecution's Exhibit 3. Opposing counsel has already been given a copy, and its authenticity has been stipulated. Your Honor, would you like a copy?
Thank you.
Officer Peterson, can you identify this document?
Yes, this is a list of all the evidence accumulated on June 10th regarding this case.
Is this an accurate copy?
Yes.
At this time, Your Honor, I move that Exhibit 3 be moved into evidence.
Any objection? They are very well admitted.
May I publish it to the jury?
Yes.
Officer Peterson, could you please tell us what the evidence is that you found at the accident scene?
Broken glass from a steel beam headlight and a broken Miller Lite beer bottle.
How about at Phil Carter's home?
In the home, there was a set of pom-poms and a baseball hat.
And finally, what was the evidence you obtained from Phil's car?
Broken steel beam headlight, 2 empty bottles of Miller Lite beer, and 1 partially smoked, hand-rolled cigarette.
Thank you, Your Honor. No further questions.
Cross-examine.
Officer Peterson, isn't it true that Gene Jones, your eyewitness, was shaken and distraught after the accident?
As expected.
Is it true that Gene Jones, your eyewitness, could not positively identify the vehicle responsible for the accident?
Correct.
Isn't it true that the aforementioned Gene Jones has to wear amber reading glasses because of a detached retina?
Objection, Your Honor, this is outside the scope of this witness's affidavit. Gene Jones is not here to testify today, and that is contained in his affidavit.
However, Your Honor, it is keep thus stating her statement here of Gene Jones.
Did you review the affidavit of Gene Jones?
No.
I'll sustain it.
Isn't it true that your only witness heard rather than saw the actual accident?
Correct.
When you questioned the victim, Mary May, is it not true that she was under heavy medication due to her unfortunate injuries which
Objection, Your Honor. The information that he is asking Officer Peterson to testify was gained through the admitting physician, which is hearsay.
Just respond to the objection.
I see nothing here to about it, Your Honor. Okay.
Well, is it being offered as an out-of-court statement by somebody who which is being offered for the truth, or are you offering it for a state of mind, or what is the basis for which you are offering?
I'm offering it for the state of mind, which the question which she interviewed was not in the right state of mind, that her testimony could not be reliable in relation to the description of the car.
I'll overrule the objection made first.
Can you please answer the question?
Can you restate the question, please?
When you question the victim, is it not true that she was under heavy medication?
I was not told that. I was told she was in a semi-coherent state.
Okay. And therefore, is it not true that even Mary May was vague about the description of the car?
I wouldn't say vague.
Well, she gave you two choices, did she not, of what color the car might have been?
Yes.
Isn't it true that before you and Officer Simpson discussed your cousin Bobby Joe Jones' chance of making the 1996 Olympic team against our client, that you had no suspect?
Objection, Your Honor. This is irrelevant.
Respond to the objection.
I'm just stating that she could be biased against my client due to her cousin.
So you're indicating to the court that the relevance is possible bias on the part of the witness?
That's correct.
All right, I'll overrule the objection. You may answer the question.
Can you repeat the question?
Isn't it true that before you and Officer Simpson discussed your cousin Bobby Joe Jones' chance for making the 1996 Olympic team against our client, that you had no suspect?
I don't understand the question.
Isn't it true that you had no suspect before discussing your cousin's chances of making the Olympics against my client?
The two incidents are not related.
Can you answer the question?
I do.
With regards to your search of our client's house or garage, did you have a search warrant issued?
No.
During the questionable search of our client's car, did you see any blood or torn clothing?
No.
Obviously, that will be your answer, since my client has already stated before that she was involved in an accident earlier with a telephone pole in Park and Mayor. Did you follow up his statement of an alibi which took place in Park and Mayor?
No, because he confessed.
But did he offer that he was involved in an accident in Park and Mayor?
Not to me.
Thank you.
Very well. Okay, thank you. That concludes the evidence on behalf of the prosecution, is that correct?
Yes, Your Honor.
All right. Defense have evidence to present?
Your Honor, we'd like to call our first witness.
Very well.
I would like to call Phil Carter.
What's your full name?
Phil Carter,
What your last name?
C-A-T-I-E-R.
You swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Yes, you do.
Proceed.
Could you please state your name?
Paul Carter,
And how old are you?
21.
Where do you live?
I live at 1720 June Lane.
And do you attend a university?
Yes.
Which university?
Westville College.
How long have you attended Westville?
I'll be a senior starting this fall.
And what is your major?
I'm an economics major.
Other than economics, do you have any other activities?
Yes, I'm on the track team.
And do you hold any honors for this?
Yes, I've broken the records in the 400 and 800 meters.
Do you have any aspiration beyond college in track and field?
Yes, I'm a hopeful for the 1996 Olympic team.
On June 10th, what were you doing that day?
I went to a graduation party thrown by one of the graduating seniors.
And how long were you there?
4 hours.
After this party, what happened?
I was proceeding home, and as I was approaching Mayo Park, I swerved and missed hitting a dog and hit a telephone pole instead. I proceeded home, and as I was backing into the driveway, I ran over my mom's azalea bush again and then parked the car in the garage.
Why did you run over the azalea bush?
It was an accident. I've done it a few times since I started driving.
Okay. And how many times?
3 or 4.
Now, with the car, a beer bottle was found. Could you explain why it was there?
Yes, the Thursday night before the accident, I'd been driving a couple of friends to a baseball game, and they had drunk the beers in the back of my car and had left them there.
Okay. Now, after you got out of the car, did you fully close the garage door?
Yes, I did.
What happened next?
I went inside to watch some TV and relax.
Okay. Continue.
I had a couple of gin and tonics, and my sister got home about an hour later, and a little while later the doorbell rang, and I believe she answered. The next thing I knew, there was an officer standing in front of me starting to question me.
What happened between you and the officer?
The Officer Simpson closed the door, shut off the TV, and sat down next to me and started asking me questions about where I'd been and what I'd been doing that day.
And what was his manner?
She was telling me to tell the truth and everything would be okay, like I was sitting there lying to her.
What did you say?
I had said that I'd been in an accident at Park and Maya, and she accused me of hitting Mary May at Market and Elm.
And did you read your full Miranda rights?
No.
Now, did you say at all that you were responsible for the death of Mary May?
No, I did not.
And did you at all drive the car that hit Mary May?
No, I did not.
No further questions, Your Honor.
Very well. Cross-examine.
Phil, you attended a graduation party June 10th, 1994, didn't you?
Yes.
And alcohol was served at this party, correct?
Yes.
And you say you drank some beer there, right?
I had 1 beer.
And around 6:15 p.m., you left the graduation party, didn't you?
Yes, I did.
And on the way home, you had an automobile accident, correct?
Correct.
And in this automobile accident, you made a large dent on the front left panel of your car, right?
Yes.
And you also broke the left headlight of your Jeep, correct?
Yes.
Now, the day of the accident, you were driving a 1992 Jeep Cherokee, weren't you?
Yes.
And this Jeep is beige in color, isn't it?
Correct.
Phil, that wasn't the only mishap you had that day, was it?
I ran over my mom's azalea bush as well.
Right, that small tree wasn't located in the middle of your driveway, was it?
No.
No, in fact, it was located on the side of your house, correct?
It was on the side of the narrow driveway.
It was on the side of the house, correct?
The driveway, yes.
Phil, in the span of 20 minutes, you encountered 2 problems with keeping your car under control, didn't you?
I believe you could say so.
Phil, let me get a couple of things straight. You own a red and white Westville baseball college cap and matching pom-poms, don't you?
Yes.
And at the time of your arrest, the pom-poms and hat were inside your house, weren't they?
Yes, they were.
Also, Officer Simpson was inside your house later the day of your accident, wasn't she?
Yes.
And she was having a conversation with you about your Jeep Cherokee, correct?
Yes.
You then told Officer Simpson about the accident you had been in that day, am I right?
Yes.
And then Officer Simpson began to read you your Miranda rights, correct?
No.
Maybe you don't understand the question. Officer Simpson began to read you your Miranda rights after you told her about the accident you'd been in that day, correct?
No, she did not.
Do you remember writing a statement for this trial?
Yes.
Your Honor, may I approach the witness? Does the statement look correct?
Yes.
Is it accurate?
Defense away.
Yeah, sure. Okay, I'm going to read a part of your affidavit and you tell me if I read that accurately, okay? I told Officer Simpson that the car was mine and that I'd gotten into an accident on my way home that day. Immediately, she started reading me my rights. Did I read that right?
Yes.
Okay, Phil. When Officer Simpson began to read you your rights, you interrupted her, didn't you?
Yes.
And you told her that you would answer all of her questions, correct?
Yes, I said I'd answer the questions.
Officer Simpson then assured you that if you told the truth, everything would be all right, didn't she?
Yes.
Phil, you're a member of the Westville College track team, aren't you?
Yes.
And you're expecting to be picked for the 1996 Olympic track and field team, correct?
Yes.
And you know that being convicted of these charges would be the end of your Olympic chances, don't you?
Yes, it would affect them.
About a week before the accident, you say that Bobby Joe Jones borrowed your car, correct?
Correct.
You also say that Bobby Joe Jones must have placed the marijuana in your car, am I right?
I believe so, because I don't remember having ever seen it before.
Phil, is this the same Bobby Joe Jones who runs track with you?
Yes.
Thank you, Your Honor. I have no further questions.
Very well, thank you. Let's sit down. Defense have additional evidence?
We left our next witness. You called Chrissy Pradler just now.
All right.
Your Honor, may I approach the bench regarding a breach of the rules of competition?
Very well.
Yep.
At this point, once you let me confer with the scorekeepers, maybe you should stop the score for a minute.
And the rules are two. You have 3 attorneys, 2 witnesses, one each playing different roles. Now in another round, they may switch the roles. They can't do it in one round. This is one round. We have to have 2 witnesses. Stop being a crazy crap, because you might be on.
Basically, the scorekeepers have indicated that the objection should be overruled, indicates that a team may use, which is not mandatory. So at this point, the witness will be sworn and may testify.
State your full name,
Tracy Trogger,
spell your last name,
Tralger.
you swear to tell the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
Please be seated.
Tracy, would you state your name?
Tracy Trogger.
What do you do for a living?
I'm a political science teacher at Westville College.
What kind of person are you?
I'm a humanitarian.
Just a humanitarian all around, or?
Yes, I helped people with AIDS and protested against the Reagan policy on AIDS.
Where do you live in relation to the Carter residence?
I live across the street.
Where were you on the day of June 10th, 1994?
I was helping the Carters repanel their basement.
As Phil arrived home on June 10th, what did you notice?
I heard him coming down the street thanks to the sound system that my son helped him put in. I saw him run over his mom's azalea bush, and then he parked the car in the garage and shut the garage door.
When Phil parked his car, what did you see?
I noticed his bumper stickers from the local rock and roll station on the back of his car.
If anyone saw this, would they recognize it was Phil's car?
Yes, anyone who's seen his car.
Speculation.
Overall.
Anyone who's seen his car knows and would easily know whose it was.
What did Officer Simpson say upon entering the house?
I asked him what was going on, and he asked me if I lived there. When I said no, he said not to interfere with police business or I'd be arrested.
Were you concerned about Phil?
Yes, I was, because the officer was rude to me, and then went and shut the door so nobody could see what was going on or try to hear anything.
So what did you do?
I stood in the room and listened to the conversation.
Did you hear Officer Simpson read Phil his Miranda?
No.
When you looked outside later, what did you see?
I saw Officer Peterson looking around inside the garage of Phil's car.
And you stated earlier that the garage door was fully closed after Phil arrived home?
Yes, that's correct.
That is all right.
Very well. All right, cross-examine.
Mr. Troutler, you have had some contact with the police in the past, haven't you?
Yes, I have.
In fact, 3 years ago, you were involved in a lab break-in, weren't you?
Yes.
When you were removed from the lab, you said that the police acted very brutally. Is that right?
Yes, they removed this brutally.
Tracy, you were arrested for the lab break-in, isn't that right?
Yes.
In fact, you were convicted of criminal trespass for that break-in, weren't you?
Yes.
When you saw Officer Simpson the day of Phil's arrest, you called Officer Simpson a stormtrooper, isn't that right?
Yes, I believe that he behaved like a stormtrooper.
Thank you, Your Honor. Nothing further.
Very well, thank you, Mickey. All right, at this point, all of the evidence has been concluded on behalf of the defense. Is that correct?
Yes, Your Honor.
Very well. All right, at this point, then, we'll hear closing statements. I guess we'll hear from who did we hear from first? I guess we hear from the defense since the prosecution has the burden of proof.
Your Honor, ladies and gentlemen of the jury, my client stands before you accused of a crime he did not commit. On the night of June 10, 1994, Mary May was driving east on Elm Street. She stopped, looked both ways, and proceeded to cross the intersection. When she got to the center of the intersection, she noticed a car light in color careening toward her. The last thing she remembered seeing was red and white pom-poms and a matching cat. Mary May had been on medication when she stated this to Officers Peterson and Simpson. Some medications may be groggy, others may make you delirious. Can her statements to Officer Peterson and Simpson be trusted to the full extent? Gene Jones, he stated that he did not even see the accident. Mr. Jones could not clearly identify Phil's Jeep as the one that he saw at the scene of the crime. Officer Simpson testified he found pom-poms in the past. So, I could equate many of the students at Westville College were found matching red and white pom-poms and a matching cat. Officer Simpson further stated that Phil gave a confession. But Officer Simpson made no mention that Phil was drunken and upset due to his accident at Park in the night. which I might add, the officers never did investigate. Did Officer Simpson have an arrest warrant? No. Did Officer Peterson have a search warrant? No. If these officers had just followed legal procedures, we would not have to be here today. After proving to you, after hearing what I and my co-counsel have just proved to you, I have no doubt in my mind that you will suppress the evidence.
Thank you very much. All right, counsel for the prosecution may make their closing statement to the jury.
Your Honor, ladies and gentlemen of the jury, as introduced by my co-counsel, I'm Elizabeth Lippy. I'd like to begin by thanking you for the time and attention that you paid to this trial. A trial which has been a desperate attempt by the defendant to shift the blame. Bill Carter has gotten himself into a great deal of trouble, and he doesn't want to take the heat. He wants you to blame Officer Simpson and Officer Peterson for what happened June 10th, 1994. No, the officers did not have a warrant to search the Carter residence or to arrest Bill Carter. They didn't need one. It's that simple. Under Pennsylvania law, there are certain exceptions to the warrant requirement. They are, simply put, that plain view and emergency searches. The searches of Bill Carter's car and house fall into each of the categories. Bill Carter's warrant was arrested valid for a simple reason. He confessed. Pennsylvania law states that a warrant is not required for a search if a police officer receives valid consent to enter and search the premises. Consent can be given by a family member or someone in joint control of the premises. Members of the jury, you heard Officer Simpson testify that Jerry Carter, Bill's sibling, welcomed Officer Simpson inside the house, and that at no time was she asked to leave. For consent to be valid, it must be knowing, intelligent, and voluntary. Jerry Carter's consent was all of these. The next exception to the warrant requirement is known as plain view. It's as plain as it sounds. If evidence is visible from a public area, such as a street, or a sidewalk, or a house into which he's been invited, then an officer's search does not require a warrant. Three requirements are needed to satisfy this doctrine. The officer's presence on the property must be lawful, the discovery of the evidence must be inadvertent, and the incriminating evidence must be immediately apparent. Now, this exception applies to the evidence Officer Peterson found in the car and the evidence Officer Simpson found in the house. First, both women had probable cause or reason to believe that Bill Carter was involved in the hit-and-run accident. The eyewitnesses told them that the car involved was large and light in color. From the public street in front of the Carter residence, they saw that the car parked in the Carter garage fit this description. They also had two pieces of evidence from the accident scene: broken glass from the headlight and a broken beer bottle. Again, from the street, they saw the broken left headlight and large dent on the Jeep's front left panel. This was all seen from the street. And once Officer Peterson took a closer look at the car, she saw beer bottles through the window in plain view. Similarly, Officer Simpson came across the hat and the pom-poms while he was in the kitchen of the Carter residence after Jerry Carter invited her inside the house. That too was permissible plain view search. The last exception to the warrant requirement involves the emergency searching of an automobile. Since cars are mobile, the chance they may be driven away and hidden permits an on-the-spot search if the officer has probable cause to believe the car was involved in a crime. We have already shown the existence of probable cause. The car fled from the accident scene, therefore it was mobile, and may have contained evidence such as blood or torn clothing, both of which could be easily removed or concealed by the driver. Because this emergency situation was in existence, the search of the car and the evidence gained was both just and proper. The next excuse, which Phil uses to shift the blame, involves his voluntary waiver of his Miranda rights. Members of the jury, you heard Bill Carter testify that he told Officer Simpson he did not need his rights read to him. He volunteered to answer all of the officer's questions. That evidence is uncontradicted. And after Phil waived his rights, he confessed. It's that simple. No matter how hard Phil Carter tries to squirm, he cannot make that confession go away. Ladies and gentlemen, remember that Phil Carter is a hopeful contender for the 1996 Olympic track and field team. He knows that being convicted of the possession of marijuana would be the end of his Olympic chances. So why not blame this on someone else too? And who would be more perfect than his top competitor, Bobby Joe Jones, who Phil conveniently said borrowed the Jeep and must have placed the drugs there. Members of the jury, it is clear that Phil Carter has no one to blame but himself. The officers were doing their job, making sure that every step in the investigation was done legally. Throughout the entire trial, the defense accused Officer Simpson and Officer Peterson of not playing by the rules. But let's not forget that it was their client who was driving while intoxicated. It was their client who struck a young lady and then fled from the accident scene. And it was their client who not only changed Mary Mae's life, but ended it. Ladies and gentlemen, we ask that when you make your decision today, you show Phil Carter that he must take responsibility for his own actions by denying the motion to suppress and allowing his evidence to be used in his trial. Thank you.
Thank you very much. You all retire to deliberate? All right, at this point, based upon the evidence presented, the arguments of counsel, the rulings of the court with regard to the specific motions to suppress would be as follows. With regard to the motion to suppress the statements and the arrest, the court will permit the statements of the defendant into evidence. The motion to suppress will be denied. There was probable cause for the arrest. It was not a custodial interrogation, and as such, that would be permitted. With regard to the motion to suppress physical evidence, specifically the hat and the pom-pom, they would be permitted into evidence. With regard to the beer bottle and the hand-rolled cigarettes, the motion to suppress would be granted with regard to those items. There were no exigent circumstances to justify a warrantless search. The other police officer was on the premises to ensure that the car was not tampered with, any contents removed, or the car itself removed from the premises. That would be the court's rulings with regard to the merits of the arguments of counsel. At this point, I would initially like to, I believe you did speak a little bit fast, however, I would maybe suggest that you slow down just a little bit so everybody could be sure to grasp everything that you want to have them understand you're saying. Mr. Carapin, with regard to your opening, I think that it was a very interesting opening. Your kind of grandiose scope of constitutional rights, I think, was a very appealing way to open your opening statement. I thought you had good voice modulation and gestures. I think the succinct statement of the issues that were before the jury and the evidence that you were going to present to establish your position regarding those was done in a good manner. I know that notes are permitted, but I would suggest that, and this really goes for the three of you, is if you could minimize the use of your notes, would probably make your presentation a little bit more effective in the future. Ms. Alamayer? With regard to your direct examination of Officer Simpson, I thought that the fact that as you were standing and your gestures and the rapport that you appeared to establish with your witness was good. I thought you asked crisp, precise, and concise questions. I thought you had good voice modulation, and I think you developed the facts fully to support the prosecution's position. With regard to the witness who was Officer Simpson, I don't know what your name was, but I thought you had a very good knowledge of the facts. I thought you did a good job answering the questions in a unhesitant fashion. and you appeared to be credible, which is something that a witness strives for. Mr. Rook, with regard to your cross-examination, I think your questions were very pointed, and I think that is good to elicit admissions which would be damaging to the prosecution's case. Again, I make my comment with regard to the notes. Again, you appeared a little bit nervous, but that's to be expected. Most lawyers are too. Let me see, I want to make sure I get everybody here. Mr. Pang, I thought that your cross-examination of Officer Peterson, you asked very good leading questions. I thought that that was very effective in making your points. Again, I think you had a good knowledge of the facts involved in the case. I thought your questions were maybe a little bit long and difficult to understand. I think if you asked a little bit shorter, precise questions, as opposed to like a compound question, may make it a little bit easier for you to deliver and for them to understand, because sometimes a quick repetition of pointed questions on cross-examination is more effective than a long question that would perhaps elicit a short answer. The witness who played Officer Peterson, I thought that you answered the questions very straightforward manner, without hesitation, had a good knowledge of the facts, and presented a very good witness. Ms. Lippy, with regard to your presentations, I thought regarding your cross-examination, I thought that it was very forceful, leading questions that you asked that really boxed the witness in, which is very effective. You had a confident manner, a good knowledge of the facts. I would perhaps question calling the defendant by his first name, because that could sort of humanize the defendant, and as the prosecution, you may not want to humanize the defendant. You would maybe like to pursue another aspect of the defendant. I thought your closing was very effective, positive, confident, and persuasive. Have I hit everybody?
Several witnesses.
I thought all of the witnesses had a very good, yes, right, we have one witness here. Okay, yeah. I thought the answers, the questions were very direct, were unhesitant. Obviously, you had a good knowledge of the facts, and I think that's effective, because sometimes if the witness hesitates, it may indicate either that they're trying to fabricate an answer or something or other. So I thought that you did a good job. And again, I congratulate everybody for their time, effort, and presentations today. Scorekeepers?
My understanding, or we were just told by the...
What do you do?
We pronounce what is suppressed and what is not suppressed.
What is that?
We pronounce what is suppressed and what is not suppressed.
I thought I did that.
No, that's what we're here to do.
You may be different than me then.
Yes.
We
concur with you. Short conference here.
What's up?
I'll do some by testimony that
We concur.
They may have to come back here again. So, do you all have any comments you want to deliver generally?
Generally, I had a question. Did this team know that the issue was going to arise as to one or two witnesses before the proceeding?
No.
Okay. I thought it was super jumping up when you saw that happening. Did you know that it was going to happen before the proceeding?
No.
When did you realize that you were going to call the same guy twice?
Oh, I mean, we knew that, but we knew, like, this is the way we practice.
Did you know that that might be a potential?
No.
Because if you had, you'd want to iron it out before the proceeding. Whenever I try to do something that looks like I might be stretching something or whatever, you say, Judge, we're going to have an issue coming up, and you let everything know before. You let everyone know beforehand. But I thought you handled it very well, recognizing it and acting. It's sort of really a procedural thing that came up that you didn't recognize, and you did that well. I like the cross-examination that you complimented on both sides. The cross-examination that was very good was that which was concise and boxed the witnesses in, drawing out the points that you wanted to help your particular side. There was some of that on both sides, and that was super.
Very well. At this point, I want to thank all of your supporters that appeared, and with that, court will be adjourned. Thank you very much.